juror deliberations. They go in the back, they deliberate, they look at their notes, they talk among themselves, they look at all the evidence. That's what's called deliberations. And as you may have seen, from various of these crime shows that are available to us now, deliberations can take anywhere from 1 hour to 2 hours to 1 week or 2 weeks, however long it takes for the jury to reach a verdict, which is the next step. And as you know, the verdict is either guilty or not guilty. And in the event the verdict is guilty and the defendant appeals that verdict, then you would have the post verdict motions. This order of the criminal trial is something that I consider to be very important, which is why I took as much time as I did to highlight all of these steps. So please be aware of this order. Next is the jury selection slide. Now, keep in mind, jury selection occurs before the trial. Okay, jury selection is the process that happens when the jury is being selected. There's a process called voir dire. It is the process of examining potential jurors for bias. This is a very, very important step in the criminal justice process because you want to ensure that the members that are going to be sitting on your jury are not prejudiced. They don't have any biases toward any issues that may come up in your case. They don't have any biases towards the defendant. You want to make sure that they are objective, they're open-minded, and they are willing to put any prejudices or anything on the side and just listen to the evidence that's presented during the hearing and base their decision on that. How you're able to come up with these questions to ask these potential jurors, because in many jurisdictions, attorneys have an opportunity to question the jurors. In the Virgin Islands, that's not the case. The judge is the one that does the voir dire process. But in some jurisdictions, like Illinois, for example, the attorneys are able to ask questions. So what happens is the jury members, the potential jury members, they get a questionnaire. They're able to fill out questions about their lives, about their personal backgrounds, their encounters with the criminal justice system, how they feel toward law enforcement, things like that. Do they have any family members who have ever been arrested? Have they ever had any family members who have been murdered by a police officer? Things of that nature. The questionnaires are very in-depth. And then you, as the attorney, you would view that questionnaire. And if you have a question or a concern or something that you would like the jury member, the potential jury member, to elaborate on, you can then ask them that in the voir dire process. Then we have challenge for cause, which is the opportunity to excuse a prospective juror for cause, such as a bias or a relationship with a key party to the case. For example, let's say that we are trying a case where the defendant is being charged with third-degree assault in a domestic violence matter. Okay, let's say that one of the jury members has indicated on the questionnaire that he or she is a victim of domestic violence. If you are the defense attorney, are you going to want that person on your jury panel? No, you're not, because that person was a victim of domestic violence, and as a result, they may have a bias against the defendant who is being charged with a domestic violence assault. So things like that. When you can establish a bias of some sort, you would want to challenge that juror for cause and get them out of there so that they don't end up on your jury. Then there are peremptory challenges. This is the opportunity to excuse a prospective juror without any reason except for race or gender. So, in other words, you can exclude someone from being on your jury just because, as one of your peremptory challenges, but the reason why you're excluding them cannot be because of their race or their gender. Okay, that is it for chapter 1. Those are the things that I found to be most important in chapter 1. So at this time, I am going to proceed to chapter 2. Let's see if I can get this here pulled up. All right, so like I said before, chapter 2, limitations on the criminal law. I'm going to start this lecture with slide number 4. So it is important to know that there are limitations on the criminal law system. There are limitations with respect to the laws that we are expected to enforce as attorneys. You just can't have any kind of criminal law out there that punishes people for doing things that infringes on their constitutional rights. Okay, so this chapter touches on some of those specific limitations, and they are equal protection of the law, ex post facto law prohibition, void for vagueness doctrine, void for overbreadth doctrine, cruel and unusual punishment prohibition, and the double jeopardy prohibition. So slide number 5 talks about the equal protection clause. This clause is found in the 14th Amendment to the United States Constitution, and it essentially prohibits discrimination against another citizen based on some characteristic, for example, race, religion, gender, sexual orientation, things of that nature. So, in other words, you cannot have a law or a regulation in place that discriminates against citizens based on these things that I just called out. It does not mean that we can't ever treat people differently. And an example of that is people under 21 cannot purchase or consume alcohol, whereas people who are 21 and older can. So in this instance, we're able to treat people under 21 differently from people who are 21 and above with respect to their ability to legally consume alcohol. But as we go on in this lecture, you'll see why it is okay to discriminate, if you will, in that capacity with respect to the alcohol consumption law. So here, figure 2.3 in your book, it lists 3 standards of scrutiny that apply to equal protection cases. Those standards are strict scrutiny, intermediate scrutiny, and rational basis. Now, in order, like I said before, in order to determine whether a statute violates the Equal Protection Clause, and that is, in order to determine whether a statute or regulation is discriminating against someone based on one of the characteristics that I said above, race, gender, sexual orientation, things like that, courts apply one of 3 tests depending on the classification in question. So the classification is what will determine what level of scrutiny should apply. If a law or a regulation classifies people based on race or national origin, it is unconstitutional unless that law is narrowly tailored to serve a compelling government interest. Furthermore, there must be no less restrictive alternative available. This is known as strict scrutiny. If a law categorizes based on gender, it is unconstitutional unless it is substantially related to an important government interest. This is known as intermediate scrutiny. Finally, a law that classifies people on any other basis, such as sexual orientation or age, is subjected to a rational basis test. This means that the law is constitutional as long as it is reasonably related to a legitimate government interest. Now, some examples, just so you can have an idea of what all this means, is there is a regulation that says that you must be a natural born US citizen in order to run for president. Let's say someone that is from El Salvador wants to run for president of the United States. You know, they meet all the other requirements. They've been living here in the United States. They got their they got their citizenship, and they meet all the other requirements to be president, except that they are not a natural born US citizen because they in fact were born in El Salvador. Let's say this person decides to challenge this law under the Equal Protection Clause, saying that it is discriminating against him based on his national origin. He's from El Salvador. He is not from the United States. What level of scrutiny will the courts have to use to determine whether or not the regulation that says you must be a natural born US citizen in order to run for president is constitutional? Well, our presidential hopeful is claiming that he is being discriminated against because of his natural origin. He is from El Salvador. Therefore, the court must employ the strict scrutiny test because the classification at issue here is national origin. And your book says that if the regulation classifies people based on race or national origin, then strict scrutiny must be applied. So the government must show that this regulation that says you must be a natural born US citizen in order to run for president, they must show that this law is narrowly tailored to serve a compelling government interest. If they can't show that, then it's unconstitutional. So the government would then say that this law is narrowly tailored to serve a compelling government interest because we don't want the leader of the United States, the president, to have any kind of foreign influences. We want to make sure that whoever is leading this country is a natural born US citizen and has this country's best interest at heart. Okay? So the fact that we don't want this country to be vulnerable to foreign influences is what has made us decide that only natural born US citizens can run for president. They have satisfied the strict scrutiny test. Some people will argue differently, but for the purposes of illustrating the strict scrutiny test and for illustrating when the strict scrutiny test applies, we are going to say that that